Hi everyone, welcome to Safi Law channel. Today's topic is plaint and essential elements of plaint. What is a plaint? Actually, the definition part of plaint which has not given in the CPC. But generally, plaint it is nothing but it is the legal document, and it is the primary step towards to initiating the suit. So through that plaint, whatever the grievances happen to the plaintiff, each and everything clearly described with the precisely and concisely without any ambiguity. While drafting of the plaint, only they have to be focused on the cause of action, not to focus on, not to describe about any of the provisions of the law or any of the evidences. It means only they should mention about while drafting of the every plaint, only mention the cause of action, whatever the grievances happen to the plaintiff, those things only describe while drafting of the plaint. Now we will discuss about the how to draft the plaint. What are the steps of the drafting of the plaint? We will discuss it now. Okay, so here drafting of the plaint, it is the main thing. It is few steps are there. That is the title of the suit, body of the plaint, relief, whatever the relief the plaintiff want, along with that signature, verification, all those various steps are there while drafting of the plaint. First thing, it is the title of the suit. Title, it is what? Head of the plaint part. Head of the plaint part is in which court the plaintiff has to file the suit. In which court the plaintiff has to prefer it. So this is completely depends upon to the cause of action. Suppose if the cause of action is the family related, then that the filing of the suit only it is possible in the family courts. That's why the jurisdictions are divided in various types. Means the courts, various courts, the various juries according to on the basis of the various jurisdictions divided into various courts, various types. First, the jurisdiction, it is a subject matter jurisdiction is there. When we discuss about the various jurisdiction, here few of the types of jurisdictions are there. That is the subject matter jurisdiction, pecuniary jurisdiction, territorial jurisdiction, original jurisdiction, and appellant jurisdiction. Like that, we have many types of jurisdictions are there. Now, just we will discuss about briefly about the what are that briefly discuss about the what are the various types of jurisdiction. Subject matter jurisdiction, it is nothing but suppose if it is related to the family related jurisdiction, then whatever the cause of action it is related to the family matter, only we should prefer to the family courts. Means the jurisdiction we can go to the family courts only. Whereas if it is related to pecuniary jurisdiction, suppose pecuniary also low cost, if the cause of action is low cost, then we can prefer to the junior courts. If it is immobile property, the cost, the value of the cause, the value of the land is more, then we will prefer to that senior civil court or the civil district courts. Like that, according to the cause of action, we can divide it and we can choose the various jurisdiction. Okay, so now same like that, if it is appeals related, then we will prefer to the appellant court. If it is relating to the any company related, then we will prefer to the company related jurisdiction. Or if it is related to the particular territory, suppose if it is a relating to the particular Secunderabad area, that if the cause of action happened in the particular Secunderabad area, if the property is situated in the particular Secunderabad area, in that particular jurisdiction only we will prefer it, and wherever that according to the pecuniary jurisdiction also. So like that, we should have to be preferred the jurisdiction, and in particular court only we will have to be file a suit. So that's why the title of the suit is very important, and that title is which is depends upon to the cause of action only. Later on, after the title of the suit, then when the original suit or I petition, whatever, everything should be clearly described. It is given by the complete information, OS number, the given by the court, along with in which years the file the suit is filed, everything the given the code only given the numbers. Then after that completion of the title of the suit, in the title of the suit only we should mention the describe the parties names. Parties names means the plaintiff. The plaintiff means if the one plaintiff is there, the description part of the one plaintiff. Suppose if the many plaintiffs are there, the description part like name, residence, place, everything. that the description part of the plaintiff we should have to be mentioned. Same like the defendant, if it is one defendant is there, then we should mention about the description part like name and residence, place, everything. If multiple people, description has to be given. So the parties' names clearly described in the title of the suit only. Next are body of the plaint. Body of the plaint, it is nothing but the cause of action, and that cause of action should be clearly described, elaborated manner, in the sense precisely only but in elaborated manner, that every person, that the court can understand what the remedy they want, what the grievances happen to the plaintiff, everything clearly described in the body of the plaintiff, in the sense in the cause of action. So this cause of action, the body of the plaintiff also be divided into few parts. That is the, yeah, it is the formal part and the substantial, formal part, and as well as that is the substantial part. Formal portion, it is nothing but there should be a statement regarding the jurisdiction of the court. The plaint must contain all the facts that point out pecuniary or territorial jurisdiction of the court. So here, then according to that pecuniary amount, whatever the pecuniary amount, whatever the loss happened, as per the facts also depends, the fact according to that facts, we should have to be prefer the particular jurisdiction. Each and everything should be clearly described. Not only that, the date when the cause happened, cause of action arise, that one also should clearly describe it. Along with that, when the cause of action happened, and when a person who filed the suit, between that limitation period, and why that person is after that limitation period, and during the limitation period, why the person is going to be filed, everything clearly described in the formal part, in the sense that the body of the plaint or in the cause of action clearly described it while drafting of the plaint. Next one, it is the value of the subject matter of the suit must be stated properly in this part of the plaint. Means the value of the subject matter. Subject matter means how much, what is the value of the subject matter, what they want, that what the remedy they wanted. Suppose if it is a immobile property, the value of the property, what the person is going to be lost. If it is relating to the any family matter, what the remedy they want, everything, the value of the subject matter also we should be clearly discussed. Next one, it is a statement regarding to the minority or any unsound mind. If a person, whether it may be the plaintiff or to the defendant, whoever it may be, if they have any minority related or any unsound mind related, the statement should be clearly described about those people, as well as the representative characters of the plaintiff. Suppose if the other plaintiff characters are there, if the representatives are also presenting something, they are also one of the part of the cause of action, each and everything they should clearly discuss. Suppose if the plaintiff has some representative or any other person also connecting to the particular cause of action, each and everything, or if it is relating to the minority related, or is it relating to the any unsoundness mind of a person's related property or anything else, that whatever the cause of action, each and everything clearly described while drafting of the plaintiff. Next one, it is a substantial portion. Substantial portion, if there is more than one defendant and if the liability is not joined, then the individual liability of each and every defendant must be shown separately. Suppose here the various defendants are there. Okay, each and every, suppose if it is the liability is conjointly, then in one cause of action, in one matter, we can describe it clearly. But if it is multiple information, multiple liabilities are there, each one's liability should be mentioned clearly while drafting of the cause of action. Now, suppose if it is X liability is the to have to give some much amount, and B's liability has to give some this much amount, everything clearly described. What are the liabilities of each and every defendant has to be clearly described while drafting of the plaint. Next one, in the same way, if there is a more than one plaintiff and their cause of action is not joined, then too the same has to be mentioned separately. Suppose if the plaintiffs are multiple plaintiffs are there, every plaintiff has a separate cause of action is there, that every cause of action also mentioned while drafting the plaint. Suppose X plaintiff is there, X plaintiff cause of action is different, Y plaintiff's cause of action is different. So each and every person, every plaintiff's cause of action has to be mentioned clearly. Otherwise, after the completion of the plaint, after might be through the amendment, if we can produce any documentation also, then that much weightage we cannot get it how we drafted primarily only while drafting of the plaint. Now we'll go to the relief. Next part, it is the relief. So this is the last part of the plaint, is the relief. The relief claim must be worded properly and accurately. So it should be accurately. Whatever the relief we want, whatever the remedy we want, might be it is relating to the any specific performance of the property, or if it is any damages, or we want the relief through any injunction related, or any kind of, we should clearly, accurately, we should have to be described. Otherwise, after the argumentation or any oral pleadings is going on, then it might not getting the proper weightage when we are going to be prefer the primarily only while drafting of the plaint. Next one, we'll discuss about the signature and verification. Signature and verification, in the sense, after completion of drafting of complete cause of action, material facts and all, then that the signature is a very important. After the relief, remedy, prayer, then the signature of the plaintiff, it is mandatory. Here the signature of the plaintiff is put towards to the end of the plaint. In case of plaintiff is not present due to any legitimate reason, then the signature of an authorized representative would suffice. So here, suppose the plaintiff, actually this is the grievance of the plaintiff. Plaintiff only has to do the signature. Okay, suppose if the plaintiff is not present at that time, if any legitimate reason is there, in such situation, any authorized person can do the signature. Or same like that, any, suppose if the what is that, the plaintiff is not present or not verified by the plaintiff, then the with the permission of the court, the other representative also can verify the plaint, whatever the information given in the plaint, everything they can verify it by the other people also, but this one has to be given the permission by the court. Next one, the plaintiff has to specify against the paragraphs in the pleading whatever all she has verified by her own awareness of the fact, and what has been verified as per the information received and subsequently believed to be true. So this is what verification, signature, after completion of the signature, verification, whatever the information given by the given, it is true and it is verified by the plaintiff. So this statement must be mentioned while drafting of the plaint. Along after that, after the verification, so the signatures completed, then that the filing of the suit, the filing of the plaint will be happen. Next one, procedure for the admission of the plaint. So what is the procedure to admission of the plaint? In the sense, first, according to the order 5 rule 9, the plaintiff must present the copies and then plaint according to the number of defendant, and should also pay the summon fee within that 7 days of the period. So here, the each and every copy, how many, if the multiple copies, if they have to be produced, the multiple copies to the defendant, and that the plaintiff has to pay the fee, summon fees, court fees, everything within the 7 days when the summons are going to be served. Okay, so this is the procedure for the admission of the plaint. Now, when the plaint be rejected, so here always the court will not accept the plaint. In some situation, suppose if cause of action is not proper, then also the court rejected. If suppose if many of the instructions given, then also not interpreted, not corrected, then not doing any of the correction, then also the plaint should be rejected. So many of the things are. So it's few of the points given here where the cause of action is not disclosed, when the relief claimed by the plaintiff is undervalued and it is not able to correct it even after being instructed by the court to do so. So here, first, when the cause of action is not disclosed, actually the main proper the first thing is what? The cause of action only. Cause of action, it is nothing but what? Grievances of the plaintiff. Whatever the cause happened, what are the grievances and what are the problems happened, what the plaintiff is going to be faced. So this comes under the cause of action. If the cause of action not disclosed, then what is the use of the filing of a suit? So that's why if the cause of action is not disclosed, then automatically the court rejected the plaint. Same like that, when the relief claimed by the plaintiff is undervalued, it's not if it is the plaintiff whatever the relief they claim, it is not in that exact amount, it is which is in the undervalued, and is not able to correct it after the many instructions also, then also the court rejected. Same like that, when the relief claim is not a proper, but the plaintiff proceeds with the plaint on a paper which has not been stamped sufficiently and fails to do so even after such court's instruction. So suppose if proper instructions given, not the stamp not sufficient, the stamp not sufficiently they filed, or if anything is relating to the court related not properly committed, then also the court rejected the plaint. Same like that, the suit, if any bar, any of the law which is barred to the particular suit, then also the court rejected. So here the various ways are there. Suppose if the court fee is not paid, suppose if the person is not paid the stamp fee, or not the stamp is not proper, if suppose if it is the plaintiff not mentioned the cause of action not properly not mentioned, or if suppose if it is the value which is the actual cause of action relief is the amount is different, and the relief value is different, it's not connected each other, in that situation also the plaint rejected. Many things are there. If it is not satisfied by the court, then that the plaint is going to be rejected. So this is about the drafting and how to produce in the court, and what are when the court rejected. So those things we have discussed in that particular class. Okay, now in the next class we'll discuss about the return statement, and we'll discuss about the along with that return statement we'll discuss about the affidavit also. Thank you.